10 seconds, 5 seconds, start. Interfering with this finding of fact again without any perversity or misappreciation of evidence by the appellant authority would clearly be outside the High Court's keen in its revisional jurisdiction. Equally, the finding of comparative hardship, which is a finding of fact not otherwise found to be perverse, cannot be upset in the manner done in the present case by the High Court. Learned counsel for the respondent, however, relied upon the judgment of this court in Badrinarayan. This was a case which arose under the Bombay Rents Hotel and Lodging House Rates Control Act 1947, Section 13, 2 of which states as no decree for eviction shall be passed on the ground specified in clause G of subsection 1. If the court is satisfied that, having regard to all the circumstances of the case, including the question whether other reasonable accommodation is available for the landlord or the tenant, greater hardship would be caused by passing the decree than by refusing to pass it. Where the court is satisfied that no hardship would be caused either to the tenant or to the landlord by passing the decree in respect of a part of the premises, the court shall pass the decree in respect of such part only. The finding of fact arrived at by the appellant authority and sustained by the High Court as to bona fide requirement of the landlord in that case was upheld by the Supreme Court. The only question that the Supreme Court was called upon to decide is the exercise of discretion under section 13(2) of the Bombay Rent Act so far as partial eviction is concerned. Paragraph 10, strongly relied upon by learned counsel for the respondent, is in the context of a partial eviction being ordered, in which this court stated, "It is expected of the parties to raise necessary pleadings and the court to frame an issue based on the pleadings so as to enable parties to accuse evidence and bring on record such relevant material as would enable the court forming an opinion on the issue as to comparative hardship and consistently with such finding whether a partial eviction would meet the ends of justice. Even if no issue has been framed, the court may discharge its duty by taking into consideration such material as may be available on record." Paragraph 13 was then relied upon, which dealt with an English judgment in Piper versus Harvey, in which it was found on the evidence accused in that case that the comparative hardship issue would have to be decided against the tenant after going into the facts. The agreement envisages several obligations on the respondent, which are required for functioning of the hotel. However, the respondent has continuously breached the terms of the agreement since its inspection, despite impassive approach and unwillingness of the respondent to perform its duties in terms of the agreement. The petitioner has continued to execute the agreement in terms of its letter and spirit till the filing of this suit.